All right, let's go on the record in cause number 2022-03-02, the state of Texas versus Stella M. Duke. Is the state ready to proceed?
State's ready, Your Honor.
Is the defendant ready to proceed?
We're ready, Your Honor.
All right, Mr. Bailiff, if you would bring in the defendant, please.
Yes, Your Honor.
All right, Mr. Bailiff, if you'll bring out the jury, please.
Yes, Your Honor.
Please read it down and ask your plea to say not guilty. I don't know if we're gonna do that part. After your regular trial, they don't have anybody cuffed like that unless they've acted up.
All rise for the jury.
And you're not in orange either during trial. You know what I'm saying? We don't have a stacked jury like this. Because the judge's dad wouldn't make the jury. And the other district judge. The victim's dad.
All right, thanks. You may be seated. Good evening, ladies and gentlemen of the jury. The trial before the court today is cause number 2022-0302, the state of Texas versus Stella M. Duke. All right, at this time, if the defendant would please rise. Mr. Walker, sir, on behalf of the state of Texas, and when you're ready, you may present the indictment to the jury. Yes. Thank you.
Thank you. In cause number 2022-03-02, State of Texas versus Stella M. Duke, charge count 1, intoxication manslaughter, 2, intoxication manslaughter, 3, intoxication manslaughter, 4, intoxication assault, 5, intoxication assault. In the 196 Judicial District Court of Hunt County, Texas, in the name and by authority of the state of Texas, the grand jury for the county of Hunt, state of Texas, duly selected and paneled, sworn, organized, and charged to inquire of offenses committed in said county and state, upon their oaths present in and to said court, that on or about the 28th day of February 2022, in the county and state aforesaid, and before the presentment of this indictment, Stella M. Duke, in counts 1, 2, and 3, did then and there operate a motor vehicle in a public place while the defendant was intoxicated by reason of the introduction of a combination of alcohol, alprazolam, and THC into the body, and did by reason of such intoxication cause the death of 3 individuals, namely Cheyenne Brock, Brylan Hill, and Savannah Middleton, by accident or mistake, to wit, by driving a motor vehicle into the person of each injured party. Counts 4 and 5, did then and there operate a motor vehicle in a public place while the defendant was intoxicated, and by reason of the introduction of a combination of alcohol, alprazolam, and THC into the body, did by reason of such intoxication cause serious bodily injury to 2 individuals, namely Scarlett Duke and Mackenzie Gladden, by accident or mistake, to wit, by driving a motor vehicle into the person of each injured party. And the grand jurors further alleged that during the commission of the aforesaid offense and the immediate flight therefrom, the said defendant did then and there use and exhibit a deadly weapon, namely a motor vehicle, that in the manner of its use and intended use was capable of causing death and serious bodily injury against the peace and dignity of the state of Texas, and signed by the foreperson Elizabeth Sherman.
All right. Thank you, Mr. Walker. And Mr. Williford, sir, on behalf of the defendant, Ms. Duke, how does she plead at this time?
Not guilty.
All right. Plea of not guilty is accepted. You may be seated. Thank you, ma'am. All right, at this time, the state may call its first witness to the stand.
Yes, sir. Judge, the state would call Officer Josh Robinson to the stand.
Officer Robinson, please. Yes, sir. If you'd raise your right hand. Sir, do you solemnly swear or affirm the testimony that you give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You may be seated. All right. Yes, Mr. Walker, when you're ready. Yes, sir.
Yes, sir. Officer Robinson, could you please state your full name for the jury?
Joshua Robinson.
All right, sir. And how are you employed, sir?
I'm currently employed with the Greenville Police Department.
Okay. And how long have you been with the Greenville Police Department?
Just under 2 years.
And are you a certified peace officer, sir?
Yes, sir, I am.
All right. And what are your duties in your present position?
I'm currently assigned to the Patrol Division. I respond to criminal offenses, take office reports, investigate accidents.
All right, sir. And were you employed with Greenville PD on or about February the 28th of 2022?
Yes, sir, I was.
Okay. And what hours were you working that date, officer? Do you recall?
6 in the morning to 6 in the evening.
Okay. And were you in uniform?
Yes, sir.
Were you in a patrol vehicle?
Yes, sir.
All right, sir. Were you working alone or were you with a partner on that day?
I was alone.
And do you happen to recall where you were at approximately 2:30 p.m.?
At Greenville High School.
Okay, sir. And why were you at Greenville High School?
At approximately 2:15, we were dispatched to a major accident in the parking lot of Greenville High School.
All right, sir. And they're at the high school here in Greenville. That is in Hunt County. Is that correct?
Yes, sir.
Okay. And that is a public place. Is that correct?
Yes, sir.
Officer, what'd you do when you arrived on scene? When you or tell the jury how you came about coming to the school and where you pulled in when you first got there.
I entered the student parking lot from Lions Lair Boulevard, going towards the indoor facility, where I observed an accident near the indoor facility with multiple victims scattered on the ground.
Right, sir. And once you got there, once you arrived, what were your primary duties there at the scene?
My first foremost primary duties are to render first aid, help the other first responders. The Greenville Fire Department and AMR were close and they beat me there, so I was assisting them due to the multiple victims. Yes, sir, I did. The vehicle was parked on the curb right in front of a light standard.
And was there any passengers or anyone in the vehicle at the time?
There was one occupant and
I'm sorry, go ahead.
in the driver's seat.
All right. And who was that driver?
Later identified as Stella Marie Duke.
And did you know Stella Duke prior to having encountered her at that time?
No, sir, I did not.
Do you see Stella Duke in the courtroom here today, officer?
Yes, sir, I do.
Okay. Could you please point her out and describe what she's wearing?
She's sitting at the table wearing an orange and white jumpsuit.
Judge, I'd ask the record to reflect the witnesses identified the defendant.
This witness has identified the defendant. Yes, sir.
Thank you, sir. Officer Robinson, what were the weather conditions like that day?
It was a beautiful day, probably about 60 degrees and sunny.
Okay. Did you observe the parking lot as you were pulling in for any impediments, the parking lot being slick, any excessive potholes, anything of that nature at all?
No, sir.
Okay. Any obstacles to avoid whatsoever?
No, sir.
Okay. So you said you came in off Lions Lair,
Yes, sir.
right? Turned left into the parking lot.
Yes.
Okay. What did you do at that point as soon as you pulled into the parking lot?
I exited my vehicle to render aid to the victims.
Okay. And while you were rendering aid, at this point, was the defendant still in the red Corolla?
Yes, she was.
What did you do prior to making contact with her, if anything?
Prior to making contact, I was still trying to render aid, help first responders, gather supplies.
Okay. Eventually, did some more help arrive?
Yes.
Okay. And you ultimately wound up going to the vehicle that had the defendant in the car. Is that correct?
Yes, sir.
Okay. Did you ask her for her license or insurance or any identifying information that she may have had?
I did ask her name and for her license. Yes, sir.
Okay. And did you engage in any conversation with her there at the time?
Yes, I did.
Okay. And did she make any voluntary statements to you?
Yes, she did.
All right, sir. And were you able to determine whether or not she had been drinking any alcohol?
Yes, per her statement, she said she had consumed a little alcohol.
Okay. And do you know what she meant by little, or were you ever able to flesh that out at all?
Based on her hand gestures and her comments, I've estimated a couple shots.
Okay. Were you able to ascertain as to whether she was under any doctor's care or anything of that nature at the time?
She claimed that she was not.
Was not?
Was not under any doctor's care.
Okay. Did she indicate to you at all that she had been, was taking any prescription medication of any sort that you recall?
She stated she took some pills, yes.
Okay. And do you recall what kind of pills she said she took?
No, sir, I don't recall what she said.
Officer, you said she had admitted to drinking some. Did you notice any odor about her to suggest that she had been drinking?
She did have a slight or moderate odor of alcohol emitting from her person.
Did you ultimately get her out of the vehicle?
Yes, I did.
Okay. Did you have a chance to look in the vehicle itself?
Yes.
Okay. What, if anything, did you find in the vehicle?
In the front passenger seat was a large bottle of Tito's vodka.
Anything besides that you may have found?
There was a vape pen for smoking different substances, also in the immediate area.
Okay, sir. Were there any other items that you had collected there in the vehicle?
I've also located a portable breath test.
Okay, portable breath test. And what is a portable breath test?
It's a device you can blow in to decipher any detectable amount of alcohol on their breath.
And what did you do with those items when you observed them?
I secured them in my vehicle and later placed them into evidence at the station.
Your Honor, may I approach a witness?
Yes, you may.
Officer, I'm going to ask you to take a look at what's been marked as state exhibits 7, 8, and 9. And do you recognize these items, sir?
Yes.
Okay. As a matter of fact, we have a chain of custody form on here. Do you see your signature there on it?
Yes, sir, I do.
And is that for all 3 of these items?
Yes, sir.
Okay. And you recognize these to be the same items that you took from the vehicle on February 28th there at the high school?
Yes.
Judge, I would move to offer states 7, 8, and 9 into evidence.
These items, this officer, we don't know where they've been this whole time.
All right, the objections are overruled and 7, 8, and 9 are admitted into evidence at this time. Yes, sir.
Judge, may I publish these to the jury?
You may.
All right, sir. Officer Robinson, you said that you eventually got the defendant out of her vehicle. Is that correct?
Yes, sir, I did.
Did you have an occasion to perform any field sobriety test on her?
Yes, sir, I did.
All right, sir. And if you could explain for the jury just quickly what standardized field sobriety tests are and what the purpose of them are as well.
The standard field sobriety tests were developed by the National Highway Traffic Safety Administration to determine impaired drivers. It's a set of 3 standardized tests, distracted attention tests, in order to determine impairment.
All right, sir. And which test did you perform on the defendant?
I performed a total of 4 tests: the horizontal gaze nystagmus, the walk and turn, 1 leg stand, and the Romberg.
And we'll start with the horizontal gaze nystagmus first. Could you just briefly let the jury know what the horizontal gaze nystagmus test is?
Yes. The horizontal gaze nystagmus is a test to see the jerking, involuntary jerking of the eye when the eye goes from side to side.
And will alcohol, or let me back up. A lot of folks have seen what they think of. Is that where you take a pen or a dot or something for the individual to look at and you move back and forth? Is that correct?
Yes, the subject is asked to follow a stimulus approximately 12 to 15 inches from the front of their face.
Okay. And if an individual has consumed alcohol, will it affect how their eyes track when you're having them look at that stimulus?
Yes, it will.
And did you see any nystagmus in the defendant's eye when you performed the horizontal gaze nystagmus on her?
Yes, I did.
And what did that indicate to you, officer?
There was There was an unknown substance of alcohol or narcotics in her system.
Okay, so the HGN, you said you performed that. You also said the walk and turn test.
Yes, sir.
All right, sir. Could you explain for the jury what the walking turn test is?
The walk and turn test, the subject is, it's a divided attention test where they are informed to stand on a straight line, approximately 6 inches wide, with their feet heel to toe in front of each other. They take 9 heel to toe steps down the line, take a series of small turns, small steps, and come back down the line counting out loud.
And could you explain for the jury what a divided attention test is and why that's important?
Yes. When a subject is impaired, they typically have a difficulty focusing on more than one thing at a time. The first portion of the test is the instruction phase. See how well they are able to understand and see if they can follow instructions.
All right, sir. And how did the defendant perform, in your opinion, on the walk and turn test?
Poorly.
Is there a scale that you use, or is it? Let me back up just a step. Like you said, it's divided attention, right?
Yes.
Part of it is to have them follow your, well, that they're understanding the directives that you're giving and to follow those, right?
Correct.
Okay. And then the other part is a physical aspect to it to see if they still have control of their motor skills, right? Have
Yes.
lost normal use of their physical faculties. Did the defendant have an issue with the mental aspect as opposed to the physical, or the physical or vice versa, or both? Or what do you recall?
She seemed to be okay with following instructions, but the physical aspect she did not have
All right, sir. And
Yeah.
what did that indicate to you?
impairment.
Now, you said you had her do the one leg stand. Is that correct?
Yes, sir.
Can please describe that for the jury as well and what that entails?
The subject is asked to stand with their feet together and then using the foot of their choice, lift their foot approximately 6 inches off the ground, maintaining their foot parallel even with the ground, and count approximately 30 seconds.
Right, sir. And how did she perform on that particular test?
She failed, sir.
And what did that indicate to you?
Impairment.
And you said the fourth that you conducted was the modified Romberg test. Is that correct?
Yes, sir.
Please explain for the jury what that test is.
The modified Romberg test is they stand with their feet together and they close their eyes, tilt their head backwards, looking to the sky, and they count, estimating 30 seconds, depending on the amount of intoxicants in their system. It could be either faster or slower than the 30 seconds.
How did she do on that test?
She failed, sir.
Now, officer, as part of your investigation into this case, you had also received some lab reports concerning the defendant. Is that correct?
Yes, sir, did.
Okay. And do you recall the results of those lab reports that you received?
She had alcohol in her system and then a high level of THC and alprazolam, commonly known as Xanax.
All right, sir. Officer Robinson, have you had an occasion to stop people for DWI before February the 28th?
Yes, sir, I have.
And would that be on few or many occasions?
Approximately about 10.
And based on the totality of what you observed there, the field sobriety test that you had had the defendant perform, did you form an opinion as to whether you thought the defendant had lost the normal use of her mental and physical faculties?
Yes, sir, I did.
And what was that opinion?
That she was intoxicated.
Once you made that determination, what did you do next?
I placed her under arrest.
And did she make any voluntary statements after she was placed under arrest?
No, sir.
Where did y'all go once she was arrested?
I took her to the station for processing and then later did the blood draw at the hospital.
There at the scene, officer, you described that there were a number of bodies. Is that correct?
Yes.
Ultimately, were you able to determine that some of those individuals were deceased? Is that correct?
Yes. Upon initial observation there, I noticed one was deceased. And then I began my DWI investigation as Officer Heron conducted the crash investigation.
And you assisted in that crash investigation, which enables you to testify in front of this jury here today. Is that correct?
Yes.
Okay. I approach a witness, Judge.
Yes.
Officer, I'm going to show you what has been marked as exhibits 1 to 6. A couple of minutes to go through those and see if you recognize what's depicted in those photos?
Who's this?
Yes, sir.
Right, sir. And these photos accurately represent what you observed there on the scene when you arrived at the high school. And then,
Yes, sir, they do.
with the exception of the state's exhibit stickers that are on them, have they been altered, modified, changed any way whatsoever from what you observed there?
No, sir.
Any reason whatsoever to believe that these aren't authentic representations of what you saw that day?
No, sir.
We have no objections to 1 through 6.
State's exhibit numbers 1 through 6 are admitted at this time.
Judge, I would ask the court to publish these photos.
Probably wouldn't object anyway. One at a time. And put on his reasons and go through it and go through the predicate and the proper stuff to make them admissible. Because what he's done right now, they're not admissible by law. But he can do it. He knows I can do it too. So sometimes it's not worth that unless it's something that they can't overcome, you know. Sometimes you don't want the jury.
All right, counsel, yes.
Officer, just a couple more questions, and I'll pass you to Mr. Williford. Ultimately, in the course of your investigation, were you able to determine that Savannah Middleton was deceased?
Yes, sir.
Right, sir. And were you able to determine that Brylan Hill was deceased as well?
Yes, sir, I was.
And did you later learn that Cheyenne Brock had died at the hospital?
Yes, sir. I learned that as I was completing my report. Just
Do you recall with Cheyenne Brock, was she actually taken by ambulance, I believe, to the hospital? Is that correct?
yes, sir. I believe she was.
Now, Ms. Middleton and Mr. Hill, they were deceased at the scene. Is that correct?
I recall Mr. Hill being deceased in front of the vehicle. Yes, sir.
Learned Ms. Brock died later at the hospital.
Yes.
Right, sir. And did you observe Scarlett Duke to have any injuries?
Not at the time. I knew she was trapped underneath the vehicle. I later learned she sustained serious bodily injury.
You understand that she lost one of her legs?
Yes, sir.
And Mackenzie Gladden, was it through your investigation, were you able to determine that she was seriously injured as well?
Yes, sir.
Okay. And based on the totality of your investigation there at the scene, did you form an opinion as to how these deaths and injuries were sustained by these individuals?
Yes, sir.
And what was that opinion?
Miss Duke was driving impaired.
Your Honor, I'd pass the witness.
Mr. Williford. Yes, sir.
Officer Robinson, we've never met before, to your knowledge, have we?
I think a long time ago we had, but you don't remember.
Maybe. And that's possible. So you've been an officer for how long now?
A total of 9 years.
Okay. And prior to Greenville PD, where were you?
I was previously employed with the Hunt County Sheriff's Office.
And so at the Sheriff's Department, did you go through training for investigations like this?
For fatality accident, sir?
Correct.
No, sir, I did not.
Okay. So you did that after you came in Greenville Police Department?
Yes, sir.
Now, you said earlier that Miss Duke, Stella Duke, my client, you said earlier that when you arrived that you performed some field sobriety tests on. Is that correct?
Yes, sir.
Now, those are standardized by the National Transportation and Safety Administration, right?
Yes, sir.
Right. And did you take any training or do you have any classes on that to learn
Yeah.
that?
Yes, sir. Prior to me being certified by the state, I took a practitioner's course to be certified. And then approximately 8 months ago, I took an 8-hour refresher course.
And when did you take that first class?
2012.
So now you created a report in this case, is that correct?
Yes, sir.
And part of that is to put down most important things in that, is that right?
Yes, sir.
And there's no mention of HGN in your report at all, correct?
No, sir.
And so are you sure you did the HGN?
Yes, sir.
Okay. But you didn't write it down in your report, is that correct?
No, sir. It's not in my report.
Now, also you said that Miss Duke, you did the walk and turn, is that correct? Had
Yes,
her
sir.
perform that. And I think you said that she, when you said, I think Mr. Walker asked you if she failed and you said, yes, she failed, correct?
Yes.
And isn't it true that somebody doesn't necessarily fail or pass? They're not pass fail tests. They're just tasked to give you information, correct?
True.
Okay. And so on the walk and turn, that's the next one that you asked her to perform, correct?
We did the one leg stand after the walk and turn.
But the walk and turn was before the one leg stand, correct?
Yes.
Okay. And I think you said that she missed heel to toe.
Yes.
Now, how many steps is that? That's 18, 9 there and 9 back, right?
She's instructed to take 9 steps down the line, heel to toe,
And then turn around and make 9 steps.
and turn around and make 9 steps back for a total of 18.
Okay. How many of those 18 steps did she miss heel to toe?
I lost count.
At one or at,
Once I got to 4.
so you can't tell the jury whether it's 4, 5, 6, or 7, correct?
No, because I was also documenting her other clues.
Okay. Now, you also said that she used her arms to balance, correct?
Yes.
Okay. Did you have her checked out medically by the ambulances that were there? Strike that. Were there ambulances at the location?
Yes.
And they were there when Miss Duke was there, correct?
Yes.
Did you have her checked out medically to see if she had suffered a concussion or anything like that prior to you performing these tasks on her?
I did not.
And so do you know whether or not she suffered from a concussion or not?
I asked her if she hit her head during the accident, and she reported to me she did not.
But did you look in the car to check and see if there's any impact on the dash or the steering wheel before you perform those tests?
No.
Now, isn't it true in your training and experience that people that sometimes hit their head become disoriented and can't comply and perform these type of tasks?
Yes, sir.
Now, at this time, when you saw Miss Duke, I think you testified that you believe that Miss Duke was the cause of the accident based on her intoxication, right?
Yes, sir.
Now, isn't it true that parking lot is not very well paved? The high school parking lot's got a lot of rocks on it,
I don't believe it has many rocks.
but there's also construction going on at the time. They're redoing the roof of the high school, right?
Yes, sir.
And there's a lot of materials out there. And when people redo roofs, what happens? They get debris and nails and things like that on the road, right?
That is true.
Did you check Miss Duke's tires to see if that it hit a nail or anything like that, or any debris to cause this accident?
I did not. Once the accident investigator was on scene, Officer Heron, my duties then transferred over to the intoxication side of it.
Now, were you there when the helicopter showed up?
I don't believe I was, sir.
Now, let me ask you real quick, the exhibits 7, 8, and 9. So 7 is, may I approach? Yes. Okay, they're over there. Thank you, Judge. This one. Is that this one? Is that this one? Yeah, you can hold the rest. I'm going to show you what's been admitted as number 7. You recognize that?
Yes, sir.
Okay. And that's a bottle of Tito's vodka that you found in the car,
Yes, sir.
but you didn't have it fingerprinted, did you?
No,
And you didn't take any DNA samples off the lid or anything around the rim to see who might have been drinking it, right?
that was not my priority. My priority was to secure the evidence, locate in the vehicle, and then the lab would test it if need be.
I'll pass the witness.
Anything else from the
No
state?
further questions, Judge.
All right, thank you, sir. You may step down. All right, state will call its next witness.
Judge, the state would call Xander Aguilar.
Sir Aguilar. Raise your right hand. Sir, do you solemnly swear or affirm the testimony that you give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, sir. You may be seated. Thank you. Mr. Walker.
Yes, sir.
Yes, sir.
Mr. Aguilar, could you state your full name for the jury?
Xander Aguilar.
And are you a student at Greenville High School?
Yes, sir. I'm a senior.
And have you gone through all 12 years here in Greenville or?
Yes, sir. I have.
What are your plans, Mr. Aguilar, after graduating? Have you got
Plan to be a diesel mechanic.
mechanic? All right, sir. Now you were there at the high school on February 28th of this year. Is that correct?
Yes, sir. I was.
There at approximately 2:30 p.m.
Yes, sir.
Were you on campus at that particular time?
I was heading to campus. Yes, sir.
Heading to campus. Okay. How did you arrive there at the campus?
Passenger of the with Stella. Duke.
And when you say with Stella, are you referring to Stella Duke?
Yes, sir. I am.
Okay. And you know Stella Duke, is that correct?
Yes, sir.
Okay. Do you see her here in the courtroom?
Yes, sir.
Okay. Please point her out and describe what she's wearing.
She's wearing an orange and a white jumpsuit.
Judge, I'd ask the record to reflect his ID of defendant.
The record will reflect that he has identified the defendant in this case. Yes, sir.
Mr. Aguilar, tell the jury, if you would, how you came about being with Ms. Duke there at the high school.
We were heading to pick up Scarlett Duke, her sister, and we were heading in from Lionsler to the student parking lot at a high rate of speed. And I attempted to jump out of the vehicle, and she hit people that we were heading towards.
Okay, so let me back up just a little bit. When did you first come in contact with her? Did she pick you up from somewhere?
Yes, sir.
Okay, where did she pick you up from?
From my house.
And y'all then went to the high school, is that what you testified to?
Yes, sir.
And you said you exited off Lionsler and turned into the parking lot.
Yes, sir.
Is that over by the baseball field?
Yes, sir. Yes, sir. Her younger sister.
When you first got in the car,
She was really relaxed and she took everything as a joke.
did you observe any alcohol?
Yes, sir. There was a bottle in between us and the cup holder.
Do you know whether or not the defendant had anything to drink out of that bottle?
She had mentioned that she did take a couple sips.
All right, once you had learned that from her, what steps did you take at that point, Mr. Aguilar?
I asked if she could blow into the portable breathalyzer that was in the vehicle.
And did you actually have a portable breathalyzer?
Yes, sir.
Okay. May I approach the judge?
Yes.
Mr. Aguilar, I'm going to show you what's been marked as State's Exhibit 9. Do you recognize that, sir?
Yes, sir.
Okay, what do you recognize that to be?
Portable breathalyzer.
Okay, and you had that with you?
Yes, sir.
Okay, and you actually required, or you had the defendant blow into this before you would go any further? Is that
Yes, sir.
okay? Did she blow into it?
Yes, sir.
Okay, and what were the results, if any, of her blowing into it?
I believe they were under the legal age or legal limit.
Legal limit?
Yes, sir.
And did you understand the legal limit to be 0.08?
Yes, sir.
Okay, and you saw that she was under that, is that correct?
Yes, sir.
Okay, and based on that, you decided to go ahead and ride with her, is that correct?
Yes, sir.
Okay. So you get in the car. Describe for the jury the manner in which she was driving on the way to the high school.
She was driving really recklessly, going in and out of the lanes over highway speed, and I was feeling under the pressure.
Okay. Let me go back just a little bit. Did you happen to see a vape pen there, Mr. Aguilar, when you got in the car?
Yes, sir, I did.
Okay. And did you observe the defendant to use that vape pen?
Yes, sir, I did.
And this is why you're in the vehicle. Is that correct?
Yes, sir.
Okay. So you described her driving, is driving fast, did you say?
Yes, sir.
Okay. Once you got into the parking lot, describe the way she was driving when she entered into the parking lot there at the high school.
She took off of line there into the student parking lot at highway speed, and she was going over the speed limit for her parking lot.
Okay. Do you recall whether you saw any pedestrians in the parking lot or in that general area when y'all pulled in?
Yes, sir.
Okay. Now you told the jury just a while ago you jumped out of the car. Is that correct?
Yes, sir.
Okay. And describe for the jury how that occurred.
While she was going up the highway speed, I opened the door and I threw my body out
Okay. And why'd you do that, Mr. Aguilar?
because I felt like I was in danger.
In danger from her driving? Is that
Yes,
correct?
sir.
So you made the determination that it was better for you to jump out of a moving car than to continue riding with the defendant in the parking lot?
Yes, sir.
What happened once you jumped out?
I could not see, but I believe that she hit pedestrians in front of her.
But you didn't actually see that, is that
No,
correct?
sir.
All right. I believe you suffered some injuries, is that right?
Yes, sir.
Okay. And describe for the jury what those injuries were.
I had a broken arm and a head injury.
Um, all right. So once, did you ever have an occasion to see, or let me back up. You said you did not see her actually hit anyone. Is that correct?
No, sir.
Okay. But after, did you receive medical care there?
Yes, sir.
Okay. Were you conscious?
Yes, sir.
Okay, you were able to see your surroundings. Is that correct?
Yes, sir.
Okay. And did you observe any bodies, be it deceased or alive, laying there in the parking lot area?
Yes, sir. In the distance, I could.
Did you know any of those people at the time, or you just observed them?
I observed them.
So you didn't know who may or may not have been there. Is that right?
No, sir.
Now, were you friends with the defendant prior to this day?
Yes, sir, I am.
Okay. Were y'all hanging out buddies? I mean, would y'all spend time together?
Sometimes, yes.
But were you familiar with her demeanor or the way you perceived her on other days?
Yes, sir.
Okay. And how would that compare to the way she appeared to you on the date of the incident?
On a regular basis, she is more like organized, and the day that she picked me up, she was more out of her body language and relaxed and took everything as a joke.
All right. Now, I know you testified that she blew under the legal limit on the PBT, but did you ultimately form an opinion as to whether she was intoxicated somehow or another?
Yes, sir.
And what was that opinion?
That she could not keep her eyes on me, and she kept looking away from me.
Mr. Aguilar, thank you, sir. Judge, I'll pass witness.
Mr. Wilford.
Mr. Aguilar, how long have you known this dude?
For pretty much my whole lifetime.
Picked her up. How hard you did.
Yes, sir. No, sir. I was mad because she wouldn't stop the vehicle. Yes, sir.
So most of this is what you're talking about is what people told you.
No, sir.
Now, you said she took vape, you don't know what was in that.
No, sir. Yes, sir. No, sir.
No further questions, Your Honor.
All right, thank you, young man. You can step down. All right, state's next witness.
Judge, the state would call Mateo Gardunya.
Mateo Gardunya, please. All right, raise your right hand. Sir, do you solemnly swear or affirm the testimony that you give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. All right, young man, you've got a very quiet voice, and that's fine, but please make sure you speak up loud and clear and directly into the microphone as you give your answers.
Yes, sir.
Counsel.
Yes, sir. Mr. Gardenia, am I pronouncing your name correctly?
Yes, sir.
All right, sir. Would you please state your full name for the jury?
Mateo Horacio Garduño.
All right, sir. And are you in high school
Yes, sir.
here in Greenville?
Yes, sir.
Okay. And what grade are you in?
I'm a junior.
Junior? Okay. And did you grow up here in Greenville? Sir, have you gone here all 11 years of school?
No, sir. I transferred this year.
So this is your first year to Greenville High?
Yes, sir.
Okay. And where'd you transfer from?
Rockwell Heath.
All right. Now Mr. Gardenia, were you on campus there at the high school on February 28th of this year?
Yes, sir.
Okay. And were you there at about 2:30 p.m.?
Yes, sir.
And do you remember where you were about that time?
I was walking to the indoor facility with my friends.
Okay. I'm sorry. Walking to the where now?
The indoor facility.
Okay. And what is the indoor facility? What are you?
I think it's the building where they play sports indoors.
Okay, okay. So,
Wasn't exactly
Am
sure.
I describing this correctly? There at Greenville High, you have the main campus, right? And
Yes,
then
sir.
you have a parking lot and an entry into the parking lot. And then you have baseball field and a practice facility
Yes.
and the stadium. Is that correct?
Yes, sir.
Okay. And you were headed to that. Is it a big building?
Yes, sir.
Okay. And you were headed that way. Is that correct?
Yes, sir.
Okay. And was anyone else with you, Mr. Gardenia?
Yes, I was walking next to Cheyenne, Brock, and Savannah. I
Okay.
don't know her last name.
Cheyenne Brock. And do you recall whether you had an occasion to see a red Toyota Corolla about that time?
No, I was kind of I was distracted.
Okay. And tell the jury how you were distracted.
I wasn't thinking much. We were walking over to the other building, and I was kind of looking around, distracted, not really paying attention to what's in front of me.
Okay. And were you startled at all, or did anything unusual happen at that time as you were walking to the practice field?
Nothing until Cheyenne pushed me out of the way, and from there it's a bit blurry.
Okay. So Cheyenne pushed you, is that correct?
Yes, sir.
Okay. You know why she pushed you?
But there was a car coming and it hit both Cheyenne and Savannah.
So Cheyenne, did she push you out of harm's way from the vehicle?
Yes, sir.
Cheyenne pushed you out of the way, and then she and Savannah Middleton were actually struck by a vehicle. Is that correct?
Yes, sir.
What happened to you when you were pushed? Did you fall down, or did you stumble, or what occurred at that point?
I fell down on the front of me, I suppose you could say.
Okay.
I got scrapes on my arms and my face
Okay.
and my knees.
And were you unconscious by any chance?
No, sir.
Okay. What did you do after you had been pushed down? What's the next thing you saw after Cheyenne had pushed you down?
The pavement.
Sir?
The pavement.
Okay. The pavement. And then eventually you got up off the pavement. Is that correct?
Yes, sir.
Okay. And what did you do at that point?
I looked around trying to see what had happened, and shortly after I hit the ground, I heard something. I think the car hit the pole. After I got up, I looked around, saw that my friends were on the floor.
So your friend, what now? I'm sorry.
My friends were on the floor.
Okay. Outside.
Yes, sir.
Okay. When you say your friends, are you talking about Cheyenne and Ms. Middleton?
Yes, sir.
Okay. And what did you do when you saw them when they were down on the ground?
I called out to Cheyenne first. She was the first one I really noticed, and I tried to see if she was still conscious.
Was she?
No, sir.
Closer to the microphone, please. Thank you.
What did you do when you saw that she was unconscious?
I called 911.
And did you get a response from 911?
Yes, sir.
Okay. Do you recall whether or not she was breathing?
She wasn't breathing.
Okay. Do you recall whether you could feel a pulse?
There was no pulse.
What did you do after you called 911? Did they give you any instructions at all?
They asked me if I could perform CPR.
And did you attempt to perform CPR?
Yes, sir.
Okay. Do you have any training in it, or were you just doing the best you
Um,
could?
In the 7th grade, I was taught at my school how to perform CPR.
And so you began performing CPR on Cheyenne, is that right?
Yes, sir.
Okay. Did you ever get a response from her?
No, sir.
How long did you continue performing the CPR?
For a couple of minutes.
Were you ever relieved by anyone, emergency medical personnel, or
Yes, sir. I believe it was a firefighter that.
Okay. So they came and relieved you, is that correct?
Yes, sir.
Now, do you recall if you saw any other individuals there at the scene other than Cheyenne and Savannah?
No, sir. I couldn't really see anybody else.
Okay. Did you later learn that, well, did Cheyenne make it? Were they ever able to revive her? Do you know?
I didn't find out that she died until earlier.
Judge, I'll pass witness.
Mr. Williford.
Yes, sir.
Mr. Gardenia, when you said you did CPR, how old are you right now?
17.
How old were you in 7th grade?
About 13.
Okay, so at least 4 to 5 years ago was when the time you had any training in CPR, is that correct?
Yes.
So when you did what you thought was CPR on this rock, are you sure you were doing it correctly?
Yes, sir.
Mr. Williford, I think your microphone is not on. Yes, sir.
Did you see who was driving any of the vehicles that day?
No, sir.
And did you hit your head on the concrete or the pavement or anything like that?
Yes.
Did it knock you unconscious or anything like that?
No, sir.
Did it make you dizzy where you had a hard time figuring out what was going on?
Yes, sir.
Okay. I'll pass the witness.
No further questions, Your Honor.
All right. Thank you, counsel. Sir, you may step down. Thank you.
Some of that witness like that. Probably.
All right. Your next witness?
Can I have just a brief moment?
Yes.
Judge, the state would call Dr. Howard Queller to the stand.
Dr. Queller? Doctor, if you would raise your right hand, sir, do you solemnly swear or affirm that the testimony you give in this cause will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do, Your Honor.
Thank you, sir. You may be seated. Okay. Mr. Walker.
Yes, sir. Dr. Queller, could you please state your full name for the jury?
Howard Evan Queller.
All right, sir. And what is your occupation, sir?
I'm a physician, a medical doctor.
Okay. And how long have you been a physician or a medical doctor?
I've practiced for a little over 44 years.
Okay. And what's your educational background, sir?
I received a bachelor's of science in zoology with high honors from the University of Maryland in 1973. I attended Mount Sinai School of Medicine in New York City from 1974 to 1978. And I received a Doctor of Medicine degree. Then I completed an internship and residency with the Public Health Service I was in Baltimore, Washington, and Texas, and a year in San Francisco. And then I went into practice about 1980 and came to Greenville, Texas with the Public Health Service and was working in a government clinic for them for several years. And then I went into private practice when I finished my public health service obligation.
All right, sir. And Judge, at this time, I would tender Dr. Queller as an expert and as a medical examiner and medicine.
Yes, Dr. Queller is accepted as an expert. Yes, sir.
Dr. Queller, in this particular case, you had the occasion to conduct autopsies on Cheyenne Brock, Brylan Hill, and Savannah Middleton. Is that correct?
Yes.
Right, sir. And during the course of those autopsies, were you able to determine the cause of death for each of those individuals?
Yes, I did.
Right, sir. And what was that cause of
The
death?
cause of death was blunt force trauma to the abdomen with rupture of liver, spleen, perforation of intestine, closed head injuries with subdural hematomas. And I think that was basically for all three had closed head injuries and blunt force trauma to the abdomen.
Right, sir. And you also had an occasion to examine Scarlett Duke and Mackenzie Gladden from the injuries they suffered. Is that correct?
Yes.
Okay. And were you able to determine whether they suffered serious bodily injury?
Yes, there was one girl lost her leg due to trauma and it was amputated. The other person, I believe, just had concussion, closed head injury.
All right, sir. And you've also had the occasion to review the lab results in this case. Is that correct?
Yes.
All right, sir. And were you aware that the presence of Xanax or alprazolam was detected in the defendant's blood? Is that correct?
Yes, sir.
All right, sir. And I believe you were aware through part of this that the defendant had admitted to drinking alcohol prior to this incident. Is that correct?
Yes, I am.
All right, sir. And I believe you're aware that the defendant had admitted to vaping from a vape pen that was labeled determined to have high levels of THC. Is that correct?
Yes, sir.
Okay. And what is THC, doctor, if you would explain for the jury?
This is a psychoactive compound in marijuana, tetrahydrocannabinol. And this particular version of marijuana is called dab or shatter. And they basically take a butane, liquid butane, which is like what you put in your lighter. And they process the marijuana and they extract all of the THC. And so you're left with a resiny, sticky substance that's sometimes almost 100% THC, which is the psychoactive product of marijuana. So when you ingest it using the vaporizer technique and the high temperatures, you get exceptionally high levels of THC, plus, unfortunately, other very toxic chemicals based on the way it's manufactured. There's a lot of cancer-causing materials in that type of product.
All right, sir. And doctor, if you could explain for the jury, and I don't know, I'm asking you this, is there any difference between the potency of the THC that was tested for, say in this case, and just smoking marijuana? I mean, just old Woodstock marijuana, you know?
You know, basically, this is a new product. I've just been reading about it. It's a much higher concentration of THC, much more mind altering, can lead to hallucinations, paranoia, acute numbness and tingling, crawling of the skin, complete psychotic episodes. And then the other health risks are, as I say, from the benzene that's used, the butane and the benzene products to extract are carcinogenic.
All right, sir. And doctor, can the combination of, say, alcohol and prescription meds along with THC cause intoxication?
Absolutely. There is a synergistic effect of the alprazolam and the alcohol. Even though her breathalyzer, according to testimony, was within the legal limit, when you combine a benzodiazepine like Xanax or Valium, Klonopin, these are also depressants to the brain. So a little bit goes a long way in combination with the alcohol, the marijuana extract, and the alprazolam.
Right, and doctor, would a person's age, would that have any effect on the potency of any combination, say a young adult, child, young adult, older adult? Is there any distinction there?
I think the effects of these psychoactive substances mixed with alcohol would have a much more intense effect on a younger person, say in their teens. I think the loss of psychomotor function, reflexes would be more impaired in that type of an individual.
All right. And I believe you've kind of touched on this, doctor, but from the medical perspective, are there any particular dangers in vaping, say, as opposed to smoking cigarettes or even smoking a marijuana joint? Or
I think based, even without the other intoxicants on board with this person, just vaping that type of a marijuana product with the exceptionally high levels of THC, that in and of itself would be intoxicating and impairment, particularly for driving.
Doctor, as you testified earlier, you were aware that Scarlett Duke lost her leg and that Mackenzie Gladden had suffered a concussion. Is that correct?
Yes, sir.
Okay. From a physical standpoint, is it over for them?
Absolutely not, Mr. Walker. These are life-changing injuries. These people will need rehabilitation. They'll need medical treatment. They'll need occupational therapy. It can go on and on. There can be long-term physical effects, certainly long-term emotional and mental effects. So this is going to be a lifelong process.
Judge, I'll pass the doctor.
Williford.
Dr. Queller, when you testified a minute ago, you testified that Ms. Duke had THC in her system.
Yes, sir.
Okay. And now Texas has no limit on THC. We have no law that says what amount of THC in somebody's system would cause somebody to be intoxicated, correct?
Any amount would be considered an intoxication
In your opinion?
unless it's prescribed by a physician. In the state of Texas, I believe neurologists and oncologists can prescribe legal marijuana, not the vapable stuff, is my opinion. I think they would just use some other edible, and it would be a controlled known amount.
But in Texas, we don't have a set amount that says that if you have that amount of THC in your system, you're intoxicated.
Yes, sir.
And also, a lot of people take prescription medication on a regular basis and operate a motor vehicle, correct?
They're not supposed to, but yes, they do.
And probably most everybody does that at some point in time in their life, correct?
It's possible. Yes, sir.
And there are people that take some medications that are able to drive perfectly because their body is accustomed or has tolerance for that medication, correct?
I suppose so. Yes, sir.
And so just because somebody has the combination of those medicines doesn't mean that they are intoxicated. That's just your opinion that they probably are. Wouldn't you agree with that?
Yes, that would be a medical opinion.
I'll pass the witness.
Anything else, Mr. Walker, of the doctor?
No further questions, Judge.
All right. Thank you, doctor. You may step down. Thank you. Any other witnesses from the state?
No, sir, Judge, the state would rest at this time.
Williford, any witnesses on behalf?
Your Honor,
of the
we'll
defense?
rest and
All right.
close.
All right. Ladies and gentlemen of the jury, at this time, I'm going to present you the charge containing the law applicable to this case. I will ask you to listen carefully as I do that. You will then hear the closing arguments of counsel, and at that time retire to consider your verdict. Ladies and gentlemen of the jury, the defendant, Stella M. Duke, stands charged by indictment with 3 separate counts of intoxication manslaughter and 2 separate counts of intoxication assault, alleged to have been committed in Hunt County, Texas, on or about the 28th day of February, 2022. To these charges, the defendant has pleaded not guilty. You are instructed that the law applicable to this case is as follows. A person commits the offense of intoxication manslaughter if the person operates a motor vehicle in a public place while intoxicated, and by reason of that intoxication causes the death of another by accident or mistake. A person commits the offense of intoxication assault if the person operates a motor vehicle in a public place while intoxicated, and by reason of that intoxication causes serious bodily injury to another by accident or mistake. Intoxicated means not having the normal use of mental or physical faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Stella M. Duke, on or about the 28th day of February, 2022, in the county of Hunt and in the state of Texas, as alleged in this indictment, by accident or mistake, while operating a motor vehicle in a public place, and was intoxicated by reason of the introduction of alcohol, a controlled substance, a drug, and or a combination of two or more of those substances into the defendant's body. And the defendant did then and there, by reason of that intoxication, cause the death of Cheyenne Brock, Brylan Hill, and Savannah Middleton, and caused serious bodily injury to Scarlett Duke and Mackenzie Gladden by then and there driving said motor vehicle into the person of each deceased and injured party, you will find the defendant guilty of the offense of intoxication manslaughter and intoxication assault, and so say by your verdict. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict not guilty of intoxication manslaughter and intoxication assault. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Your verdict must be unanimous. And after you have arrived at your verdict, you must use the form attached hereto by having your foreperson sign his or her name to the particular form that conforms to your verdict. Following the arguments of counsel, you will retire to consider your verdict. Mr. Walker, sir, on behalf of the state of Texas, and when you're ready, you may present your closing argument. Yes, sir. If you would use a microphone, please, Mr. Walker.
Oh, yes, sir.
Yes, sir. Thank you.
Ladies and gentlemen of the jury, I want to thank you. I know you've all been very attentive. You've all paid very close attention to the evidence that was presented to you here this evening. It's no easy task being a juror, but it is easy, I would suggest to you, to use your common sense, right? Just use your good old common sense in regards to this case. What the state had to prove and the elements of this offense that we have put evidence forward to prove is that on or about February 28th, 2022 in Hunt County, Texas, that Stella Duke operated a motor vehicle while intoxicated, and due to that intoxication caused the death of Cheyenne Brock, Brylan Hill, and Savannah Middleton, and caused serious bodily injury to Scarlett Duke and Mackenzie Gladden. This offense was proven beyond a reasonable doubt from the testimony that you heard here today. Officer Robin testified, and you heard what he had to say, that when he showed up on scene, had a situation at the high school, he comes down Lyons Lair, he takes a left, he goes into the parking lot, he sees there are bodies around, sees a vehicle that there's an accident there in a red Corolla. He sees the defendant is the driver that's behind the wheel, gets her out, and what does he observe? Smells alcohol on her breath, that she had used a vape pen and had ingested THC, a vape pen that later through a lab analysis showed that it had very high levels of THC in that vape pen. Saw her demeanor, the field sobriety test that he had her put her through, the horizontal gaze nystagmus. He testified as to that, which is an indicator of being intoxicated. Had her do the walk and turn and said that she failed many of the clues of the walk and turn. The one-legged stand, that she performed poorly on the one-legged stand. All of these tests are designed to give the officer some idea as to whether or not the person is intoxicated, right? Driving, as with anything else, is a divided attention endeavor, right? We have to be able to see where we're going, understand our speed, understand the surroundings that are in front of us, know traffic laws, know what those are, but we also have a physical element to it as well, to be able to hit the brake when we need to hit the brake, to swerve to avoid any obstacles that may be there. That's why those field sobriety tests were given, because they show both of those things: loss of normal mental use and physical use of the faculties. And based on the evidence that you heard, according to Officer Robinson, Stella Duke, this defendant, had lost both of those. That shows that she was intoxicated. That's what this evidence shows, that she was intoxicated. And the offenses that we have with intoxication manslaughter, if by reason of that intoxication caused the deaths of the 3 individuals that died, then we have the offense of intoxication manslaughter. Take that same standard and apply it to intoxication assault with the 2 individuals that were assaulted. You can take everything Officer Robinson testified as to intoxication and apply that to the assault as well. You heard from Xander Aguilar, the individual that was in the car with Ms. Duke shortly before the accident, said that he was so concerned about her mental state that he actually had her perform a portable breath test that he had with him, okay? Had his own portable breath test that he gave her to blow into, and it was below the legal limit, okay? So he was satisfied she was okay to drive, but what did he testify to is that as they drove further and he observed her driving more and more, that she was driving reckless, she was speeding, she pulled into the parking lot way, way too fast. He testified that there were no obstacles there in the road wasn't slick. It's a beautiful day, according to Officer Robinson, no potholes that would have caused any problem whatsoever. Think about the level, I mean, seriously, think about his testimony. If you're literally riding in a car and believe you need to jump out of a moving car because you think that is safer than staying in the car with an individual, I think that in and of itself suggests just how impaired Ms. Duke was, as Mr. Aguilar testified. Mr. Gardunia, Mateo Gardunia, his testimony was a bit limited. I think his credibility is beyond reproach. He didn't make anything up. He didn't see everything, right? He told you what happened. He got pushed down. And when he came back up, he saw that 2 of the individuals had been injured, but he didn't embellish. He just testified as to what he saw. And despite his heroic efforts to save Cheyenne's life, he was unsuccessful. The paramedics came in, CPR they attempted, but she later passed away also. And finally, you heard from Dr. Queller. I think Dr. Queller's testimony was very key. I think it's very pertinent to what we're dealing with here. He talked about the dangers of vaping and just how horrible that is, the impact that it can have on people. In particular, I asked him the question specifically as to whether there's some enhanced impact or if it's worse on younger people than it is on older people. And this is a medical doctor that's been practicing since 19 clackety-clack, and he was able to tell you that that is not good for young people. As a matter of fact, it's beyond not good. It is horrible. The impact of that on young folks' brain, on their mind, the way it can affect them. They're essentially taking poison, is what he testified to, with the benzenes and everything that's involved in it. But you take that and you couple it with alcohol, right? The vape pen with the alcohol, and you couple that with the medication, the Xanax or the alprazolam, that essentially created a toxic combination for this defendant. And unfortunately, it resulted in the deaths of 3 individuals and serious bodily injury to 2 others. Now, that's all I have to say now. I'll come back with my final rebuttal after Mr. Williford has made his closing argument.
Mr. Williford.
May it please court,
Yes, sir.
counsel.
Yes, sir.
Ladies and gentlemen of the jury, I'd ask you to look at the evidence, go back over the last few days that you heard. And the state has failed to meet their burden, proof beyond a reasonable doubt that my client, Ms. Duke here, number one, was she intoxicated? What evidence do we have of that? We have Officer Robinson that performed some field sobriety tests, but he can't recall what she might have failed or what she did fail. He didn't have it written down in his report of what he has. So we don't know, and you don't know for sure. But let's go to look at Mr. Aguilar. What's his testimony? Well, she was drinking, maybe she was vaping. You got a disgruntled person that's angry with her. She won't go out with him. He's got reason to make it up. So we don't have good, solid evidence there. And then we get to the doctor, Dr. Queller. What did he tell you? Texas doesn't have a minimum limit for intoxication for THC. We know she's not intoxicated on alcohol. We don't know the limits and any other levels, so we don't know whether or not Ms. Duke is intoxicated. Was she driving the car that caused this accident? Absolutely, she was. But was she intoxicated? There's no evidence there. There's not sufficient evidence. And did she even cause the death of all those people? I mean, Mr. Aguilar testified, he jumped out of the car. Well, common sense tells you open the door, you push out. What did you push off of? Push off Miss Duke in that little small Corolla, push off the steering wheel, cause her to swerve into people. It wasn't her intoxication if she was intoxicated. The cause of the accident is kids being careless, but not from intoxication. And, you know, it's sad and it's terrible that all these young people are gone, and nobody's more sad than Miss Duke here. But it's not because she was intoxicated. There's so many more factors there, and we'd ask you to look at that evidence and find Miss Duke not guilty.
Thank you. Mr. Walker.
I would say I agree with Mr. Williford that this is sad and it is terrible, no matter how you look at it, all the way around. And whether or not Ms. Duke is sorry, maybe she is, maybe she isn't. What I think is more important is that on this particular day, this defendant made a choice, okay? Made a choice to vape, use THC, made a choice to drink, made a choice to take alprazolam or Xanax medication, made a choice to combine those drugs at one time, made a choice to drive recklessly on the way to the high school, made the choice to not slow down or to change her way of driving when Mr. Aguilar begged her to, okay? Made those choices. Our folks that we lost in this case, Ms. Cheyenne Brock, Brylan Hill, and Savannah Middleton, and Scarlett Duke and Mackenzie Gladden with their injuries, they didn't make this choice. This wasn't a choice for them. This wasn't a choice for these people's, their parents, these kids. We lost 3 kids and had 2 kids seriously injured. They didn't make that choice. And I want to stress that, and because I do want to make this point because I think it's very, very important, is that oftentimes just human nature would be to extend some mercy, I suppose, because someone is young, right? We have a young defendant. But I think it's important to keep in mind in the state of Texas, the age of criminal responsibility is 17 years of age, right? However, under certain circumstances, kids as young as 15, 16 years old can be charged as adults, okay? Depends on the case. And that being the case, if you have a young person who believes that they can do just whatever they want or act any way that they want or behave however they want, and there's not going to be any repercussions because they're young, I think this jury should send a message that if you have young people that are acting as adults, which I would suggest to you that that's what we have here, that causes 3 deaths and 2 injuries, 2 individuals that will never, they are marred from now on, that this defendant should be held to face the consequences of this offense as an adult, because this was a horrible, horrible offense. I ask that you use your reason and common sense when you go back and deliberate, and thank you for your time.
All right. Thank you both, counsel. Ladies and gentlemen of the jury, at this time, I'm going to hand the bailiff the verdict form along with the charge. I will ask you to step down and begin your deliberations. When you have reached a verdict, knock at the door so the bailiff can bring you out.
All rise for the jury.
All right, ladies and gentlemen, you may be seated. We will stand in recess until the jury has reached a verdict. I do ask you may speak quietly amongst yourselves, of course. But please continue to maintain order here in the courtroom until the jury has announced that they have reached a verdict. Thank you. All right, come to order. The jury has reached a verdict. Daniel, when you're ready, you may bring the jury into the courtroom.
Yes, Your Honor. All rise for the jury.
All right, come to order. The jury has reached a verdict. Daniel, when you're ready, you may bring the jury into the courtroom.
Yes, Your Honor.
All right, thanks. You may be seated. Ladies and gentlemen of the jury, I have been advised by the bailiff that your jury has reached a verdict. I would ask your foreperson, has the jury reached a unanimous verdict in this case?
Yes, Your Honor.
All right, if you would deliver that to the bailiff for deliver to me for inspection. Thank you. All right, Ms. Duke, if you would please rise to receive the verdict of the jury. We, the jury, find the defendant Stella M. Duke guilty beyond a reasonable doubt of all 3 counts of intoxication manslaughter as charged in the indictment. We, the jury, find the defendant Stella M. Duke guilty beyond a reasonable doubt of 2 counts of intoxication assault as charged in the indictment. As to punishment, the jury has elected punishment in the case of Cheyenne Brock, 20 years and a $10,000 fine. With regard to Brylan Hill, 20 years and a $10,000 fine. With regard to Savannah Middleton, 20 years and a $10,000 fine. With regard to the injury of Scarlett Duke, 10 years and a $10,000 fine. And to Mackenzie Gladden, 10 years and a $10,000 fine. Ms. Duke, I don't doubt for a moment that when you set out that day, you did not intend to hurt and to kill the people whose names I have just read. But as noted by Mr. Walker in his closing argument, you did intend to consume alcohol, you did intend to consume pills, and you did intend to consume THC. As a result of each of those decisions, 3 people are dead and 2 people are seriously injured. And countless numbers of people in this room and throughout this community have had their lives forever changed. And some of them, friends, family members, parents, will never, ever again be the same. As some might argue, as Mr. Walker noted, that your young age calls for a lighter sentence in this case. for mercy, or perhaps even for a second chance. But I disagree. Cheyenne Brock got a death sentence. Brylan Hill was shown no mercy, and Savannah Middleton will have no second chance because of the decisions that you alone made. I do feel for you because of your age, but your punishment must be a measure of the overwhelming damage that you have caused, of the unending pain that you have inflicted on this community and the people throughout this community who knew and loved these people. It is therefore the considered judgment of this court, ma'am, that each of the 20-year sentences be stacked, that each of the 10-year sentences be stacked, and that you serve a term of 70 years in the institutional division. You will not be eligible for parole for 30 years. This may seem harsh, but it is a small price for you to pay for what you have taken from the families of these victims. Mr. Bailiff, if you'd remove the defendant from the courtroom, please. All right, ladies and gentlemen, thank you for being here today. Thank you for your attention. Thank you, ladies and gentlemen of the jury. At this time, we are adjourned. Good luck to all of you and God bless. Thank you. Ladies and gentlemen, if you would hold on for just a moment. I'm sorry, I missed one thing that we were going to do. We're going to bring Stella back in for some applause. I think she's taken some abuse tonight, and so let's bring her back in here for a little bit of applause for her part in this process. Yeah, bring her back through.
Thank you.
Sorry, they had to go get her. I think she's already on the bus to TDC, so. Folks, we've also got the victims coming out here in just a moment. And they're on their way out here. And let's give them a round of applause as well. Good job, kids.